Let me call to order the town of Waxahachie Grove special magistrate hearing. Today is Wednesday, October 17, 2012. It's about almost 10:30. And I think rather than swear in witnesses at this moment, I'll do it in a moment. We just have the one case on the agenda, correct?
Yes, sir.
To do that, yeah, maybe we are into swearing in witnesses. And I think you may know, though, I need to recess it at noon. I don't know, I suspect that's not going to be enough time.
It will be done.
It will.
Will be enough time?
Yes.
Well, that's good. Okay. So then that's not an issue. I won't take up more of the time. Let me swear in whoever's going to testify. Any folks, anybody over here going to testify? Okay. Do you swear the testimony you'll give will be the truth, the whole truth, nothing but the truth?
Yeah.
Thank you. And just so we have a record of who's here, why don't we go around the room here and we'll get everybody's name.
Russ Elton, code enforcement officer, Jim Taylor.
Beverly 2, president of 2 and Taylor Inc., representing Waxahachie Grove's code enforcement.
Braden Carrot, planning commission, Waxahachie Groves.
Mark Cuddy, town manager, Waxahachie Groves.
I'm Michael Cirillo, town attorney, town of Waxahachie Groves.
Jeff Brown, attorney, I represent Glenn Smiley and Seth Breyer.
Seth Breyer.
Beck Hislop, resident and business owner, Waxahachie Groves.
Okay. Would you gentlemen like to give an opening so I know what this is about, or do you just want to jump in?
Well, let me just start. I'm
Yeah.
Cirillo, town attorney. We have 2 different violations here this morning. I was going to turn it over to Ms. Tu for the pole barn type structure without a zoning permit. I'm just gonna.
You're gonna let me do my thing?
Nah, I'm gonna go through it. I'm gonna do it.
Okay.
The town council at its last meeting directed my office to request the attorney general opinion on the change in state law that to section 604.50. Before it said it exempted non-residential farm buildings from state building codes and county municipal building codes. 2010, that law was changed. It was vetoed. The veto was overridden in 2011, and now it says that non-residential farm buildings are exempt from building codes in any county and municipal code. Took out the word building.
Okay.
So
the question is it subject to the
Land
town's
development
code,
right.
which is not a building permit thing. It's more of a zoning.
Correct. And
Okay.
so what the town council authorized our office to do is request an attorney general opinion to determine or confirm whether we can apply our land development regulations to non-residential farm buildings. And so that is pending. The request hasn't been submitted to the attorney general's office yet. It will be presented to the town council at November 20th meeting for authority to send, and then we'll get the opinion. So to be fair to the respondents, what we'd like to do in that case, what we've done in other similar situated cases, is continue that, not have it heard until we get that opinion back. Get that opinion back, then depending on the outcome of that opinion, we'll either be back here or we won't, or in the meantime, if the case is resolved. But to be fair, we want to pull that case. We're not dismissing it, we're just we're not.
Well, sort of bifurcated, I guess we would
Right.
call that, right? Okay.
Okay, and so we're only here on the first violation, which is the non-permitted uses on property located in AR, and for that case, what I do is turn it over to the code department to present that one.
Do you want to give a statement?
I'll reserve opening, I'll reserve my opening.
But I don't think he's objecting to continuing the pole barn case.
I am not.
We're in agreement on that. Okay, that's fine. And we'll just proceed then with the first charge, which would be on 20.015. Okay.
Thank you, Mr. Magistrate. For the record, my name is Beverly 2. I'm here for Waxahachie Grove's code enforcement. And for the record, I'd like to enter the fact that this is Waxahachie Grove's case number 2012-277. Town of Waxahachie Groves, Florida, the petitioner versus Elaine Smiley. The property control number is 41-41-43-17-01-804-0040, location at 556 B Road, Waxahachie Groves. Mr. Magistrate, this case came to our attention serving to a Taylor Inc., serving as Waxahachie Groves Code Enforcement on November 15th, 2011. I would like to add that that wasn't the first time that this case had cropped up its head here in Waxahachie Groves. As far as we can determine, this case goes back to at least 2008. But nonetheless, when the affidavit of complaint came in on November 15th, 2011, the alleged violation was for selling hay and feed and shavings and other activity serving as a retail outlet on the site. I will submit to you exhibit number 1, which is that complaint.
We have extra copies I could give you, Mr.
Thank you, Mike.
Which is the complaint and all the property data from both the property appraiser and the tax collector, assuring that the property owner in this case is indeed Elaine Smiley. Elaine Smiley is the property owner. As you heard earlier, it is our understanding that Mr. Byers is the leasee on the property, and we've already discussed the fact that we do have a notice of appearance for Mr. Brown to serve as their representative. I do not believe Mrs. Smiley is here today.
But let me ask before you move on, any objection to the exhibit, Mr. Brown?
No, sir.
Okay. Exhibit 1 will be admitted.
Once we receive the affidavit of complaint, Mr. Russ Elgin, and he certainly is here to answer any questions that you may have in terms of what he saw on site, did the site inspection. Upon conducting that site inspection, there was the issuance of a correction notice, as we've talked about previously. In Waxahachie Groves, a correction notice is more or less a courtesy to the property owner to make the corrections and to abate any alleged violations on the property prior to being issued a formal notice of violation. In this case, as we discussed, the continuance of violation number 2, so for the record, I will enter violation number 1 in the correction notice. Violation number 1 in the correction notice was for a non-permitted use of property located in the agricultural residential zoning district. The property was being used for retail sales, RV lot, and commercial activity. The violation was or alleged violation is in reference to Waxahachie Groves Unified Land Development Code, Article 20, Residential Zoning District, Section 20-015, copy of which has been provided in Exhibit number 2, which I'll provide you, Mr. Magistrate.
Now I'll come to it. Thank you.
At that time, the corrective action was for the property owner to cease all business activity, and they were provided a compliance date of April 25th, 2012. Also within that correction notice are all of our affidavits of service per Florida state statute and the photos of the activity, the alleged violation and activity occurring on the property at that time.
Before you go on to the next one, let me let Mr. Brown look at that and let him know if he has an objection.
No objection.
Okay.
Thank you.
Exhibit 2 then is admitted in evidence.
Prior to and then as of the compliance date of April 25th of 2012, Mr. Elgin did conduct additional site inspections to determine whether or not compliance had been obtained. Compliance did not occur prior to or on the original compliance date. As a result, we issued a notice of violation, the more formalized notice, official notice, again with the violation number 1 being non-permitted uses of property located in the agricultural residential zoning district, and the property being used for retail sales and commercial activity. The new compliance date in the notice of violation was for May 25th, 2012. And with that, Mr. Magistrate, I will enter exhibit number 3.
Oh, thank you.
Also attached to exhibit number 3, again, are the affidavits of service, along with the certified mail receipts and UPS tracking confirmations to serve as notice to that effect and compliance with Florida state statute.
Any objection to exhibit 3?
No, Your Honor.
Thank you. Again, continuing to conduct inspections of the property, Mr. Elgin found that non-compliance was or compliance had not been obtained as of June 6, 2012. As a result of that, we did issue a notice of hearing for the order of violation. That is in Exhibit 5, which I'll submit for the record. Oops.
We have exhibit 4. Did you guys see exhibit 4?
No.
Copy of exhibit 4. You said it was fine.
Oh, I'm sorry. I stand to be corrected. It's Exhibit 4, not 5.
That you're doing right now?
Yes, sir. Okay. Apologize for that. This is the notice of hearing for the order of violation. Compliance had not been obtained by May 25th, 2012. And again, you will find, Mr. Magistrate, that in this exhibit there is the notice of hearing, the affidavit of service, and site photographs that were taken as of that date.
Any objection to exhibit 4?
No.
Exhibit 4 is submitted.
Mr. Magistrate, the original notice of hearing order of violation, the hearing was scheduled at that point in time for June 20th, 2012. We issued again on July 6, 2012, and this is in exhibit number 5, which I'll provide for the record.
What? I don't have 5 yet. You don't have 5 yet.
No, sir.
I only have one copy of exhibit 5.
Okay, well, why don't we do this? If you only have 1 copy of exhibit 5, I have a copy, and you can just email me another one.
Okay.
She's got 5.
Oh, she's got the 5.
It needs to go to Mr. Brown.
Any-
We need an
any-
extra copy.
Not that one.
That one goes to him. Wait a minute.
One goes to Mr. Bennett,
Okay.
one goes to Mr. Brown.
Exhibit number 5, again, contained within that exhibit is the notice of hearing for the order of violation scheduled for July 6, 2012. At that time, it was an order of violation, notice of hearing, order of violation continuance, scheduled for August 15th, 2012. You'll find in there where we did come to you, Mr. Magistrate, on that particular hearing date. And at that time, we had been asked to continue this in order to meet with the property owner and, or by the property owner's representative in order to discuss the violations and be able to provide some options for them to be able to come into compliance. So there was an agreed order granting continuance and rescheduling the hearing. The hearing was rescheduled for September 13th of 2012. Also contained within Exhibit 5, again, is our affidavit of service and the site photographs of the property and the non-compliance as of that date.
Okay. Any objection to Exhibit 5?
Oh, yeah.
It is so admitted.
Exhibit 6, we continue to conduct site inspections to determine whether or not compliance had been obtained on August 13th, 2012, and I'm going to provide you with exhibit number 6. It was found that the property was still in non-compliance, and it's the exhibit is just photographs demonstrating that. And exhibit number 7.
Let me just stop you. Any objection
I'm
to
sorry.
6?
No?
And for the record, I'm going to provide you with exhibit number 7. You'll find there again is the special magistrate notice of hearing for the order of violation continuance scheduled for today. We did provide service to the property owner pursuant to Florida statutes. Attached to this, again, is the notice of violation, the accompanying Town of Loxahatchee Groves ordinance number 20-11088, describing permitted and non-permitted land uses, the affidavits of service as well as photographs demonstrating the property was still in non-compliance as of the service date.
Okay. Any objections to 7?
No?
Okay. So all exhibits 1 through 7 are admitted in evidence.
And Mr. Magistrate will reserve additional comment based upon the respondent's testimony.
Okay.
Yes, Mr. Heislip, the complainant is here today to also provide testimony as well.
Okay.
No, I'm just trying to figure out what we're doing next.
Me too.
Bear with me one second.
Yeah, no problem.
So then we'll just call Mr. We call Mr. Isaac. That's it.
Thank you, Mr. Magistrate, we're ready.
Okay.
Mr. Magistrate, we do want to hear from the complainant.
Right.
We will have testimony about what the uses are on the property.
Okay.
That-
Yeah, that is fine, and I don't know if you have anyone else who's going to testify, because I mean, other than these documents, I know nothing.
Right, we'll just have an explanation about what our zoning code permits in this zoning district.
Right, yeah, I have the code from the exhibits, and, you know, apparently there's the contention it's not a permitted use, correct? And I don't know, I'm anticipating whether there's a non-conforming use issue, maybe not, but I would suspect that may be an issue. So, okay.
So I guess we would call it
Right,
complaint.
like I said, we'd like to reserve any additional comment from staff for rebuttal. Mr. Herseth is here, the complainant.
Okay, okay. We're going to put witnesses there, I guess?
Yeah, this is the hot seat.
That's it, no.
All right, we just wanted to have him part of the group instead of standing.
Sure, yeah, we don't want him in the back. Could you state your name, please?
My name is Beck Hislop,
And how do you spell your last name?
Hyslop.
And the first name, excuse me?
My first name is William, everybody just calls me Beck. I go by that.
Okay, and what is your address?
My home address is 3828 B Road.
Okay, I don't know how you want to handle,
What I would ask Mr. Islip, I'm sorry.
Hislop.
Hislop, I apologize.
No problem.
Just to explain to the magistrate the circumstances that brought you to file the complaint with the town, and what you observed, and what the uses are that you're concerned about.
From what I understand in the town, everything's complaint driven. I have a business on Okeechobee Boulevard in Waxahachie Grove, 22948 Okeechobee Boulevard, where we have a retail business similar to his. We've been around since 1989. We pay commercial property taxes in excess of $50,000 a year. We have to deal with all the commercial regulations, including and not limited to anything that has to do with the fire department, fire sprinklers, etc., handicap parking, handicap aisles, etc. The biggest issue we have, and it's not that anybody has a business, on the contrary, I think it's great that people want to have businesses in their community. I've never said anything against people not having businesses and trying to make a living. My biggest issue is that a business like his is not having to jump through all the hoops that we have to jump through. We pay in excess of $100,000 a year, having to deal with all these regulations and or property taxes, where somebody in this situation does not have to deal with that. Our rents are higher just because it's commercial property that is on commercial. And that's the reason we brought it up. I don't have a problem with him selling it. My mother raised me to understand that competition is good. It keeps everybody honest. And I'm all for competition. But I think we all should be playing on the same ball field.
What exactly are the uses that concern you on the property?
More than anything, the retail.
Excuse me, I'm going to object on the grounds of lack of a predicate as to how Mr. Heslop can know any of the answers to these questions.
okay. Now, how are you familiar with the property?
I drive by it almost every other day.
Your Honor, my objection has nothing to do with the property. It has to do with his understanding of regulations, zoning, and what's wrong or what's permitted or what's not permitted.
Okay, well, I understand that. That's more a conclusion, correct? I would say conclusion under the code, but I think if you know, you would be able to testify what you've observed.
I have no objection to his observations.
Right.
And honestly, that's what I intended with the question, was just tell us what you've observed on the property.
Cancel my objection.
Okay.
I'll clarify, retract, and just describe what you observed on the property.
What I observed is just a typical retail feed and hay business. Banners on the fences for advertising, sales of horse equine products, including hay, feed, shavings, fly sprays, anything that has to do with the equine industry. I've observed it literally by driving right in front of it. The reason I do is I live on B Road, he is on B Road. If I go to Southern, I go right in front of his business. From what I understand from the research I've done on the Palm Beach Property Appraiser's Office.
And, Your Honor, I have to object. This is what I'm objecting to. Is his research, his online, and his hearsay talking or without proper predicate talking about what zoning codes are and what title codes are and things outside of his observations.
Okay. Any response?
Well, I mean, we're gonna put in the record what the town's records demonstrated per land use tax category zoning. So we
Yeah,
don't really need
that I
from
think,
the-
I'm
from
sorry.
the complainant.
Yeah,
So,
I think that would be beyond this witness's purview, but let me just ask you, I mean, you indicate you drove by, I mean, do you know there are retail sales there personally?
Yes.
And how would you know that?
Friends of mine have actually shot there and shown me receipts.
May I move to strike on the grounds of hearsay and seeing documents that are not produced today?
Now that I will argue against, because this is not the formal trial. You can consider hearsay in this type of hearing. It just cannot be the sole basis for any determination that you make.
Yeah, I would overrule that objection for that reason. Anything else you've observed at the property?
Apart from just sales, no, sir. I mean, just that it looks and like a retail business. I haven't pulled in there, I haven't stopped in there, had no reason to. I've just driven by there multiple times.
Anything else you want to tell me?
That's my complaint. It's just I don't think we're playing on the same field. You know, we have all these expenses and they don't have
Okay,
expenses.
I understand your point. I guess, I mean, the question would be, does that violate the code? I mean, what we're looking at is the code, not whether it's fair or not. I mean, for purposes of this, and I understand where you're coming from
Go ahead.
as far as your business.
That's about all I've got to say. That's been my.
Okay.
Yeah.
I don't have anything further. And then
Are there any questions,
appreciate
Mr.
your
Webb,
comment.
you'd like to ask?
Your Honor, I would prefer to reserve in the interest of time, but that would require him coming back. If that's a concern, and if I'm asked to do it now, I will do it. We have talked about how we're going to proceed. Would you like me, Michael, to?
Well, it's up to, what we talked about is we're gonna put on our case, and it'll be up to them if they wanna start their case or not, but, shortness of time, and we think we can narrow the issues. We felt important to go forward with our case, and then not get a final order today, but we would work with you on scheduling a special set before December 20th. So I don't know if Mr. Islip could come back or not. And the reason we wanted to go ahead and have him on today, is so that we can be done with him, so we wouldn't have to bring him back a second hearing.
Okay.
So,
I'd leave that to you. If you want to come back, not knowing when we're going to get scheduled.
I don't know what day it would be, and I don't know what my schedule's
Why
going to be.
don't you, if you're prepared to do the cross now, why don't you do that? And I guess if for some reason you needed to recall him, we could work with that.
You'd like the same playing field between competitors,
I don't have a problem with that.
and you agree you're a competitor.
Yes,
So you do feed and hay and
Yes.
tax sales, et cetera.
yes, sir.
And you jump through some hoops.
Yes, sir.
Hey, tell me what hoops he hasn't jumped through.
Commercial property taxes.
So he would pay who? You or the county or the city?
The
Who does he
county, I'm
pay?
not expecting to get paid for any of this. I'm expecting for the laws that I have to follow, that any other business in Los Angeles Grove would have to follow.
So you're saying pay commercial taxes?
Yes, sir.
So if I was his lawyer and I took him to the tax collector's office, I could jump through the hoops necessary to be your competitor?
If you were done that way, yes, sir, I guess you could.
Is there anything besides taxes I need to do, such as zoning?
Well, anything
Well, I
like,
guess, I'm just gonna object, because for the same basis that he objected to, the witness saying he's not qualified to give any opinions and research on land use, he's asking him now, asking what his client would have to do to make his property whatever approvals needed, and I think that goes beyond the scope of what we've established his expertise to be. If he wants to go down that road, then he needs to withdraw his objection and allow Mr. Hysep to testify about what he started testifying is correct. Can't have it both ways.
Yeah, I don't find that all that particularly relevant anyway, in the sense that I understand where he's coming from.
May I address relevancy?
Sure.
I've asked the city and the county,
Yeah.
and now I'm going to ask the complainant, tell me what I can do to comply, tell me where I can go, and I will do it, and I will do it. So if he can tell me what I can do to be on a level playing field, I'm going to do that. Maybe not today, but tomorrow. So he may not be the one that gives me my answer, but I would suggest it's relevant.
What,
How,
maybe I'm missing the issue of the case. The issue of the case, it seems to me, is that the town has a code that says these uses are permitted, certain ones. And I guess the question will be is what is happening at the site permitted or not? And I don't know whether, I mean, if it needs a rezoning to do it, then that would mean it's not permitted. But I don't know if this gentleman would be the one to answer those. I think if your question is, how does this gentleman get his use permitted, I think that would be more directed to a town witness rather than him, because I don't know your expertise at all on zoning and all, and you're just coming in and testifying what you saw at the property, as far as I understand.
My only expertise I have is whatever research I've done, but no offense, sir, but you told me that my expertise was null, so I guess I don't have any.
Well, I'm not saying it's no. I'm going to now ask you what hoops he can jump through, if allowed, what hoops he can jump through to be your competitor.
And again, I object to
Yeah,
Ralph's.
I'd sustain that objection. I don't think that's pertinent for what the code violation is.
Then respectfully, that's all I have.
Okay.
Good.
Yeah, thank you.
Thank you, sir.
Yeah,
Okay, Mr.
No,
Magistrate.
not that. What we need to decide, and I'll ask the questions, I guess it would be, who can put on the record, based on their expertise, whatever, the town, the status of the property. Unless he wants to consent, what the underlying land use and zoning is on the property.
I will consent to the documents if that's your
Do
question.
you have the map and the zoning map to show? Otherwise, we're gonna need to put it on the record. What, under the town code, what is this, that's called
Braden Garrett,
Braden Garrett, and what's your title?
planning technician.
And what's your scope of duties for the town?
I review all business tax receipts, site plans, I assist with the application processes,
Is part of that to be familiar with the land use map of the town?
yes, as well as the land development code,
Okay, and you have reviewed those documents regularly in your duties?
yes,
Okay, have you reviewed those documents in relation to the property located at 556 B Road?
yes,
And what is the land use for 556 B Road under the town's comprehensive plan?
agricultural residential,
Okay, and what is the zoning for the property located at 556 B Road?
zoning is agricultural residential,
And are the permitted uses for the zoning category agricultural resource set forth in some document?
pardon?
Are the permitted uses for that zoning category set forth in some document?
Yes,
And which document is that?
it would be in the Unified Land Development Code,
And you have reviewed the land development code?
yes,
Okay, and is the land development code provision that was attached to which exhibit was that attached to?
With for the record, Beverly 2, code enforcement, exhibit number 2. The courtesy notice or the correction notice contains ordinance number 20-11-008.
And you're familiar with ordinance 2011-008?
yes,
Okay. And that's in exhibit 2, and that shows the agricultural, residential, permitted, and accessory uses. Mr. Denton. That's all I have.
We agreed to reserve any
Okay.
discussion.
So, what we, Mr. Down, at this point, what we discussed with the respondent is that rather than them go through the defense, which will likely take us beyond 12, what we'd like to do at this point, since we've got our case relating to the town's in the record, is reset without an order today, continue the case, and if we can do it this morning, get a date, if not, coordinate between our offices, a date before December 20th
Okay.
to pick up with the respondent's case at that point.
So the town, though, is resting more or less?
Yeah. Well, I mean, we're resting the violation under the town code, okay? If we have a hearing, we're obviously gonna have a rebuttal to respond to that, to those type of things. But our case in chief is basically a mathematical equation. This is what the zoning code says, this is what's there, and this is equals that. If there's a defense raises some of those issues of fact or whatever, of course, we're gonna wanna respond to any defenses, affirmative defenses, those kind of things that we need to. But for purposes of establishing the violation, we've got the documents in the record, the testimony, the complainant, and others. And so what we'd like to do at this point, rather than start a defense, is continue the on that date. Without going into a lot of stuff you can't be troubled with, we may, we will probably have further discussions with the respondent for that date.
Okay, is that acceptable to you?
Entirely accurate. The reason, Your Honor, for the December 20th kind of demarcation is November is not good for me, and I also leave town on the 20th, so we're trying to coordinate that date, either to come back or to come to you with some resolution.
Probably the early part of December.
Okay. You know, I can check with my office, which I should have brought a calendar if I didn't, but do you want to pick a date, or you want to just work it out?
I'm capable of picking a date.
How about December 12th, Mike, that's the second Wednesday.
I'm wide open on December 12th.
December 12th.
And that is what would be-
Wednesday.
That is
It's
a
a
Wednesday.
Wednesday. That would be the
Second.
usual, that wouldn't be the usual meeting.
That'll be the second
It'll be the
Wednesday.
second.
No, the usual meeting I think was going to be on the
19th.
20th, because that's the third Thursday was the 20th.
December 12th, a Wednesday.
Yes.
That works for moi.
Yeah, that would be fine. Any feel for how much time we will need as far as picking a time to start?
Well, I'm okay with starting as early as everybody can get here, because I just drive straight here, so I'd start at 9.
9 would be better for me, rather than hanging out all morning.
That's why does 9 work for you?
Either 9 or before works for me.
Why don't we do 9?
Okay.
We'll stay civilized. Okay, so we'll do December 12 at 9 o'clock, and at that point, I guess we'll let you folks begin with your case. And anything else we should be talking about today?
We've been doing some talking and will continue, so I think you can count on us continuing that motive.
Okay, that's always good.
No, because everything else. Oh, no, sir,
Everybody set the date, you folks are all okay?
We're okay with
Sort of
it, yes,
listen to
sir.
the attorneys here. Okay, that date should work for me as well. Okay, we will then recess to be continued for this case on December 12 at 9 a.m. Will it be here, or do we know?
We will make the effort to acquire the room. With this much notice, we'll do it, so it shouldn't be a problem.
Okay.
We will advise you, obviously, if there is an...
Yeah, that's what, I mean, it doesn't matter if it shifts, just so everybody knows. Okay,
I have a room in Boca if you'd like to take a day trip.
we'll try for
Just
here.
kidding.
We'll try for here. Okay, I guess we will adjourn and pick up then.
I don't have it. Did you have? It was the one that was given on the agenda. That's what's on the actual, we're just going to go before them on which one.
That's okay.
Here's what we're doing. I haven't had a chance to call her back this morning because I haven't been in the office. I think I told her yesterday, once I knew the date, last night, we were going to continue November, she can come to council. That's that fence, yeah. I told her, I said, this is what we're doing, I'm going to call her back this morning, yeah. You don't have to worry about it, I'll take care of it.
Okay.
Yeah, you can tell them now if you want to, that's fine. Yeah. Then we'll get in the rest of the calendar for November and...
Oh, but I couldn't change it.
Oh,
The thing is, you can't change
well, yeah,
it.
you want to get it in now.
Because what happened is when he sent the notices out, I haven't had a chance, I caught it too. I haven't had a chance to say
Yeah,
anything.
that's what we another meeting we got on.
Because on the 25th, I'm getting my car serviced.
Yeah.
In Fort
Yes.
Lauderdale.
Everything from
Get
November.
longer, I'm not gonna go for the Waxahachie.
So we're gonna make.
Well, maybe we can leave it.
No.
Everything's not old.
Your office is
I have an
here.
I
office
mean,
in Delray.
Magic Properties is not gonna be ready.
There.
Oh, no, Magic Properties will be doing this. Site plan, so.
Okay, confirmed.
Confirmed, okay.
So I'm going to hang out for November, you know, I guess, there is nothing scheduled for sure.
So the only thing that I could do was say, I don't see this and that. And once it's-
Did you knock that off? That's off, right?
Let's do 1:30
Because the next time I know what mine is, saying, the next time that we may want to for the
You want to
record.
do it in
The zoning.
So Friday the 26th at 1:30 in your office.
Let me see if Mark or somebody wants to.
Mike, it's confirmed, December 12th.